Confidentiality is the foundation for trust in the patient-caregiver relationship. And as a healthcare professional, it is expected that any information you learn while providing care will remain confidential. Efforts to maintain and protect confidential information once focused solely on paper medical records, and this remains a concern. But as communication technology has made it possible to easily store and transmit enormous amounts of medical information through computerized databases, fax machines, and the internet, there is an increased danger that confidential information may be revealed to inappropriate individuals. With the ongoing task of maintaining patient privacy becoming increasingly difficult, now more than ever, when confidentiality is at stake, healthcare professionals need to ask, who needs to know?
In this program, we will introduce new federal laws that have been passed to protect patient privacy and describe how those laws will affect you and your institution. We'll provide an overview of confidentiality issues in healthcare, explore a breach of confidentiality, and examine reporting laws which are exceptions to confidentiality. Finally, we will present a few scenes that illustrate situations which may be helpful in discussion or in role-playing. In 1996, Congress passed the Health Insurance Portability and Accountability Act, or Hipaa, which mandated the creation of new patient privacy rules. These rules were drafted and went into effect in 2000.
Many specifics of these rules are primarily of interest to those who set policies and procedures in your institution, and those who maintain the security of your computer system. Most of the rules deal with the sharing of information with third parties outside of your institution. However, you should know the general outlines of the new Hipaa rules. The general rule is that patient authorization is required for any disclosure of protected information. This includes both routine and non-routine use and disclosure of information. Healthcare providers have full discretion in sending part or all of a patient's medical record to other providers for treatment purposes. But patients must be given detailed written information on their privacy rights and how their information will be used. These new rules are meant to prevent unauthorized disclosures to anyone outside your institution. This includes prohibiting companies that sponsor a patient's health plan from gaining access to that patient's health information for employment purposes without the patient's authorization. The rules cover all forms of information, including paper, oral, and electronic information. Hipaa provides both civil and criminal penalties for violations that can range up to fines of $250,000 and 10 years in prison. Even if the name is not given, as long as the particular patient is identifiable from the stored information, the rules still apply. One person in your institution will probably be designated as the privacy officer. It is their responsibility to know your state's laws and federal laws regarding privacy and confidentiality, as well as your facility's policies. Be sure to work with your privacy officer to learn about any authorization forms that may be needed and when to use them. While the new laws primarily deal with disclosure to those outside the institution, confidentiality within the institution is just as important. There are direct ways you can help prevent breaches of privacy within your institution. For example, never leave information on computer screens where unauthorized persons can gain access. Locate and position screens so persons passing by cannot view information. And never share computer access codes with unauthorized persons. These codes should be randomly changed for all authorized staff on a periodic basis. Printed records should be shredded prior to recycling or discarding. It is important to realize that on the average, 75 people have access to a patient's computerized record. This is a situation that needs to be monitored in order to maintain patient privacy. Sometimes information from medical records is sought in order to do medical research or for other purposes. We need to remember that the patient maintains the right of control over that information. The need to have patient authorization releasing information for research will vary. Work with your facility's privacy officer and make sure you're familiar with your employer's policies on all authorization procedures and forms. Now, let's look more closely at some general issues of patient privacy and confidentiality. Issues that go well beyond the security of computer records.
The right to privacy is implicit in the United States Constitution, and the American Nurses Association Code states that the right to privacy is an inalienable human right.
Everyone who comes in contact with the patient is responsible for maintaining patient confidentiality. This includes ensuring auditory privacy during assessments, exams, and procedures. This obligation to maintain confidentiality applies to both medical and personal information learned during the course of examination, care, and treatment, including information learned from reports or the medical record, from other caregivers, or from the patient's family and friends. With some exceptions, which we will discuss later, only information pertinent to treatment and welfare should be disclosed, and it is disclosed only to those directly concerned with the patient's care. In addition to federal laws, state laws further define specific types of protected medical information and the type of healthcare providers who have access to this information. Since these laws differ from state to state and can be more specific than federal law, it is important for nurses to know the laws of the state where they practice.
Now we will look at a few examples that demonstrate how to avoid breaches of confidentiality.
She's been on painkillers for 2 years.
And this is somebody I would know.
Rumors are an obvious breach of confidentiality.
It's not like I don't work here too, you know. Come on.
All right. Her husband is a big shot in city government, and that's all I'm going to say.
Hey, you're talking about little Jeffrey's cousin.
Sometimes the natural urge to talk about confidential information is hard to resist, but telling just one person may result in a rumor being spread over an entire institution and beyond.
The new Hipaa rules are meant to be a floor under privacy laws that already exist. Many states and the federal government have stronger privacy laws in special cases, such as for patients who have HIV or AIDS, and Hipaa will not affect those laws. Let's look at the dangers of breach of confidentiality in a special case like this.
Nurse's station? Yes, he is. You're his mother? I suppose I could give you that information. Could you hold, please? Thank you. Let's see. It says pneumonia, and he should be discharged by the end of this week. That's what the chart says. Was the pneumonia caused by the HIV? I don't know for sure, but it probably was. You're welcome.
Even if the patient had authorized releasing information to his family, how did the nurse know she was talking to his mother?
In most states, it is a criminal offense to reveal information like this when a patient has HIV. In addition, no patient may be tested for HIV or AIDS without their consent, and no information regarding the results of these tests may be provided to anyone other than the patient. But there are ways to politely handle inquiries, such as telephone calls.
Nurse station. You're his brother? Hold, please. Can you please tell me the code number? I am authorized to give information to family members, but you must have the code in order to prove that you're a family member.
Code systems can be set up for safeguarding information and for providing information over the telephone, but only if the patient authorizes that the information can be given out.
I'd rather you not give out any information. I can tell them myself.
All right.
When authorization has not been given, there are effective ways to withhold information without offending friends or loved ones.
Is it really going to be necessary to perform surgery?
I'm sorry. Mr. Hansen has asked that he be allowed to give information regarding his condition himself.
you may wish to practice ways you can politely but firmly withhold information.
I'm sure you understand we value the privacy of our patients. I'm not allowed to give out that kind of confidential information.
For families seeking information about future treatment or prognosis, it may be best to refer them to the attending physician.
I'm sorry, but you'll need to get that type of information from Dr. Talbert.
If you are authorized to provide information, find a place that provides auditory privacy where you will not be overheard by others.
Why don't we go in here where we can speak privately?
Laws regarding access to the chart or medical record vary from state to state. Be sure to know the laws in your state and the policies of your institution.
Hi, I'd like to see my father's chart.
All right, hold on.
If access to the chart is prohibited by law, the patient's written authorization may be required.
Oh, I'm sorry, but I can't give you access without your father's written consent.
Depending on state law, some institutions may even require that the physician be present when the patient or family views the medical record.
Smile.
The taking of photographs or home videos may also be an invasion of privacy.
I'm sorry, but to protect the privacy of our clients, we only allow photography when there's written consent by all the subjects.
You should learn your institution's policies and procedures for authorizing disclosure. In many cases, written authorization from the patient is required. Now, let's examine the dangers of breach of confidentiality in some special settings.
In the home health setting or a skilled nursing facility, it is sometimes easy to forget that you are not a friend of the patient or resident. You are a professional, and you have to be very careful about discussing information about that individual with neighbors or friends who come by to visit.
How are things going in there? Are they getting along any better?
I tell you, those people fight like cats and dogs. No wonder they're getting a divorce.
Unauthorized disclosure of personal information can easily get back to your patient and may destroy the trust inherent in the caregiver-patient relationship. Let's see how this could have been handled better. Learn to limit yourself to general comments or turn a conversation to another subject.
How are things going in there? Are they getting along any better?
Things are going just fine. How are you this morning?
In long-term care, where the residents have gotten to know one another well, there may be questions about another resident.
Oh, Agnes is coughing all the time. Why does she do that? Does she have bronchitis? Helen told me she had TB.
Avoid discussing a resident's condition with another resident. Only general comments are appropriate.
She does have a bad cough, doesn't she? It's good of you to be concerned. You let me know if she's keeping you up at night, okay?
Yeah, I will.
The law requires much more stringent protection of privacy in psychiatric and chemical dependency settings. In most hospital settings, the patient's name and the fact that they were admitted is not considered confidential. But this is an entirely different matter in a psychiatric or substance abuse setting.
To West. I don't think he's here. Hold on. Yeah, he was discharged to the outpatient program and isn't scheduled to be here today. You're welcome.
It is a violation of federal law to reveal or even confirm the identity of a patient in any psychiatric setting or any drug or alcohol rehabilitation program.
Federal law requires that information about drug and alcohol abuse treatment be kept completely confidential, including whether an individual ever was a patient in such a facility. Let's see how inquiries should be handled.
CDC, may I help you?
In settings where even confirming the identity of a patient is against the law, there are simple responses that can be effective in protecting patient privacy.
I'm sorry, but I have no information on anyone by that name. I'm sorry, I can't even tell you whether or not there is someone here by that name.
In addition to patients with HIV, psychiatric, or substance abuse problems, there are others who may be particularly at risk for a breach of confidentiality.
Normally, the parents of minors are automatically given information about their child's condition, but in many states, cases involving pregnancy, sexual abuse, rape, or other special circumstances are treated differently under the law, and disclosure even to parents may be a serious breach of confidentiality. When a caregiver becomes a patient in the institution where he or she works, it usually prompts the interest of staff members who are not providing direct care in the case. However, co-workers have no special right to information or to examine records.
Breaching confidentiality has consequences not only for the patient, but for the caregiver and the entire institution. The Hipaa rules call for both civil and criminal penalties for revealing patient information to third parties without authorization. The civil fines do not even require any wrongful intent. Your institution may be fined for accidental and unknowing violations. In addition, administrative sanctions can be imposed by boards of nursing and can include censure, suspension, or revocation of one's nursing license.
Be sure to work with your privacy officer and learn the policies and procedures that are designed to prevent any inadvertent release of information. Breaches of confidentiality may result in a patient lawsuit against you as well as your employers. Healthcare organizations have suffered significant monetary losses and damaged reputations as a result of lawsuits over breaches of confidentiality. Lapses of judgment that damage a patient can result in disciplinary action by the employer. A breach may even result in your suspension or termination from employment. In some particularly sensitive areas, such as HIV information, violations may even bring a criminal action against you. It is important to learn all you can about privacy procedures so you can avoid these situations.
There are important exceptions to a caregiver's obligation to keep information confidential. These exceptions are set forth in your state's reporting laws. For example, psychotherapists hold a special position in the eyes of the law in order to encourage people to be open and honest in therapy. Therefore, protections have been established in laws to keep information told to a psychotherapist confidential. However, there are very significant exceptions to that confidentiality.
There's no way he's going to get away with this. Mark my words. That scumbag is going to be dead as soon as I get out of here.
In circumstances where you have an identifiable victim, you have a duty to warn that third person if you have good reason to believe that your patient may cause them harm.
I don't know whether he's serious, but he is threatening to kill the person he was fighting with.
If you are not sure whether the threats are serious, don't decide on your own. You may be wrong. Report any threats to the appropriate person in your institution so that the threatened person may be warned.
He doesn't mean to do it. He just gets so mad he can't stop himself.
There are also laws to protect individuals from abuse. There are laws to protect children, adults, and the elderly.
When you encounter any patient who appears to have been physically abused, you have a duty to report your suspicions. Normally, the police or county social service agency must be notified by you or your supervisor. Laws vary from state to state, and caregivers have a legal obligation to know the state laws about reporting child, domestic, or elder abuse.
Other exceptions to confidentiality may include apparent criminal wounds, such as gunshots, knife wounds, and poisonings. You may also have to report communicable diseases and deaths of an uncertain nature. When in doubt about whether or not you need to report, ask your supervisor. In order to protect your own career as a caregiver and protect your institution, you need to be aware of confidentiality. You should take the time to learn your institution's guidelines so that when you are working, you will know automatically when to give out information and when to withhold it. And when you are off duty, you need to leave that information at work.
The following scenes are presented to help with role-playing and to generate discussion about issues of privacy and confidentiality. You may wish to stop the tape after each scene for a discussion or for thought.
You're a home health care worker, and your patient has active tuberculosis.
I heard she has TB. I spent most of the summer with her. Do you think I need to be tested?
You are a psychiatric nurse and your patient is angry about being on a 72-hour hold and has a history of violence. The doctor that initially requested the hold is no longer involved in the case.
That doctor that put me in here? No way he's gonna get away with this. He'll wish he never heard of me.
Your patient in the ER presents with bruises that are not consistent with a fall.
I fell. Nobody laid a hand on me. Just mind your own business and fix me up.
As a home health worker, you are aware that your patient lives with her son and his wife.
Hello?
Hi, Nurse Jones, please.
Speaking.
This is the Medicare office. Our records show that your patient lives alone and has no family that can help out. Is that true?
You are approached by a coworker from a different department.
Hey, Clark. Howdy. How's it going?
Fine.
Say, your patient, that guy that the paramedics brought in here the other night?
Yeah, I remember.
Well, one of the paramedics is a friend of mine now. This patient, he bled all over my friend's hands before he had a chance to put on gloves. Now, we know this patient is a drug addict, and I know he's been tested for HIV because I saw the order. Now, my friend saved this guy's life. You think you could look at the results and tell me whether I need to tell my friend if he's got to worry or not?
You are approached by a coworker from a different unit.
Hi. We're trying to gather documentation to get Dr. Forgetful booted out of here before he kills somebody. Do you know what I mean? I understand there were some problems with Mr. Carter yesterday. Do you mind if I look at his chart?
You are signed onto the nursing terminal with your password, filling out a patient record when a coworker arrives.
Dr. Sims wants the medication records for Mr. Wilson in a hurry. I don't have time to sign on my own password. Could you scoot over? Thanks.
When information must be communicated, make sure it's for treatment or billing or other uses that are within the law and within the policies and procedures of your institution. Healthcare providers are caring and giving people, and part of that caring attitude is doing your utmost to respect the privacy of everyone under your care.